is going slow, I'll try that, I might switch off my camera in between, right? So that there is clear audibility and we are well connected. So, officially, I would like to welcome all of you again for the academic counseling of business law today. We are going to cover the last module, that is the sixth module today, uh, which is, as I have shared yesterday also, which is covered with, or rather, it has 3 units. So, yesterday, what we did was the module which was all about the different types of IPRs and the areas of the intellectual property right. Today what we do is about the entire block which is about business and sustainability. Now business and sustainability, the entire module is divided into 3 units: the 12th, 13th and the 14th unit as per the content which is available on e-Gyan Kosh for all of you. It is about environmental protection and sustainability, one of the laws which is competition law, and another law which is called as the consumer protection law or the consumer protection act. So what we do is I am going to start first with the first unit of that module, that is about business sorry environmental protection and sustainability. So let me just share my screen with you all and then we are going to begin. As the recording is on, now you can write your names in the chat box. That gets your attendance recorded.
Okay.
Now I hope the screen is also visible to all of you. Is it visible?
Is visible now.
Okay, thank you so much. So let us talk about environmental protection or environment protection and sustainability. So when you talk about this environment or this word environment, I would say there are various areas which are part of environment and it is very important, from the business point of view, while you are doing any kind of
Yeah.
business activity, that it should not bring any harm to the environment.
Yes.
Requesting to please mute yourself, requesting all of you to please mute yourself, otherwise it is going to create disturbance in the class. Fine.
It,
If you have any queries, anything, you can just drop that in the chat box.
it
Suleiman, what happened?
is
You have anything to say? Suleiman? If you have anything or any concern, you can please put that in the chat box. Because as I said that, when it is going to be, you unmute yourself, then it becomes the system, there's a noise from your end and then it becomes difficult for me. Fine. So as I was just talking about, let us move on to the entire 12th unit. I'll just share my screen again. just let me know. Can you see the content?
Yes, ma'am.
Yes, ma'am.
Okay. Okay. So let us just start now. I'll be the content is already visible. So let me just start with an introduction to what this unit is all about. See, in past many years, we have seen that environment plays a very very important role when you talk about different types of business activities after industrialization, after different types of developments which are happening. Ultimately, there is a kind of a disbalance which has created between the environment and the activities, business activities, because of that. So it is affecting in totality, if we say in a very major sense, different growth, different types of problems are there related to pollution of air, water, oceans. From industries, there is so much of waste which is coming out, and ultimately, it is affecting the common masses or the population at large. So, it is very important that people should be aware about these environmental issues and the activities of human beings, such as of deforestation, burning of fossil fuels, changing land, rising population, excessive use of natural resources, dampening the industrialization is majorly, as I was just talking, is affecting the environment. So these issues have led to formulation of various acts, and this also says that to grow, to develop is not bad. To come up with industrialization, talking about economic growth, maximizing of profit is something which should be done. But with that, it is important to take care of the environment in which we live in. So there are many certain issues which are taken up, and ultimately, when we talk about, there are certain laws which have come up for the protection of environment. So in this unit, you have those laws or acts which are Water Act of 1972. I'm talking about from the India's point of view. In India, when we talk about approaching towards environmental protection, so there are certain acts which have been formulated. Like there is a protection, air prevention and control of pollution act, which is of Act of 1981. We have water prevention and control of pollution act, which is the Act of 1974. We have further the act which is by the constitution in the 42nd amendment, which is there, which talks about all certain issues related to the harming of the environment and how it can be protected. So ultimately, it is very important to understand that what are these issues and challenges which are increasing by our modern day developments. So in India, we have experienced a virtual explosion of public interest litigations, which we call as also PILs. And on these PILs, environmental issues and courts have assumed a very proactive role in the form of the public educator as well. So the policy makers, the administrators here in India, now they have come up with different kinds of awareness drives, making people understand, coming up with different ways in which the environment can be protected. So to talk about the holistic and the comprehensive approach regarding environmental protection, these regulations should be in place to prevent any activities which is leading to the harm to the environment. So in India, we have the constitution, as I was just talking about, the 42nd amendment, which was actually in the form of the directive principles of the state policy as well and of the fundamental duties. We have that every citizen has to follow, that if we talk about certain like acts which are there or the laws which are there, it is important for the people of state and country to understand that these constitutional rights are there or these constitutional obligations are there, which focuses on or pressurizes you to protect, preserve and safeguard the environment. So under Article 21, it is mentioned that what are the protects to protects of rather right to life as fundamental right. So enjoyment of life is good. Attaining the right of life to enjoy human dignity, it encompasses within its ambit. But protection and preservation of environment, the ecological balance, free pollution of air and water, sanitation without which life cannot be enjoyed, these all areas should also be taken care. And that is where it was that by different PITs which were there, that is public interest litigations under 32 and the Act of 226, this environmental wave have come up, which actually led to these acts. So now let us talk about these acts one by one. I'll be just covering the major points of these acts, because it is the content which is available is too excessive, and you can just read that later so that you can have an understanding about it. So we'll be talking about the Environmental Protection Act of 1986, the Water Act of 1974, Air Act of 1981, Forest Conservation Act of 1980, and also the Wildlife Act of 1972. Okay. So, any questions, any concerns till now? Can we move ahead? Any questions? Shall we move on?
Yes, we should move on now. Maybe toward the end of the
Okay.
class, if there is query, we will ask.
Sure. Definitely. You can write that in the chat box and I will be, taking your questions from there. So let us just continue. I'll share my screen again. Yes, ma'am.
Good evening, everyone. Good afternoon and good evening. And I just
Hello,
request
ma'am.
Rasmeet,
Yes,
hello,
ma'am.
make one or two students make them a co-host to help you. However, they all are already guests, but sometimes they are in trouble.
Yeah, ma'am.
So
Yeah, now we are not having that problem which we used to have it previously, ma'am, because now I think they can join the meeting because
I
they
I
are
I
already in the guest.
actually I made all of them are guests now. So that
Yeah,
is
yeah.
why they
So
are
I
not
just,
facing.
yes, ma'am.
Even
Now
though
it is not problem. Sure, ma'am. I'll make one of them.
okay, okay.
Farida, can I make you?
Yeah, you can. It's okay. I'm here.
Sure. I've made you as a co-host. So, by
Okay, ma'am.
chance, if there is anyone who would like to, who joins, because it happens, you know what, when I start sharing my screen and I need to connect back with you, so I need to again stop sharing the screen and then need to come back to have a kind of discussion with you. So, at times, that is, a concern for me, but then it's okay. I'll just go ahead by sharing the screen. As you see the screen, you can just let me know. Okay, I hope the screen is visible now to everyone.
Yes, it's visible.
Okay. You can prepare few
Yes,
notes with
please.
me, while I'm talking about certain things, I would request that if you want, you can have a, like paper or a register with you, and you can keep on making certain notes, the important things that will help you even later. So, talking about the Water Act of 1974, as I was just saying, that it is very important now. Farida, I think there's somebody who wants to join. Could you just help me in making that person join?
I have. I have.
Thank you, Farida. So, now let us talk about those who have joined late. I request you to please write your names in the chat box. Okay, that marks as your attendance as well. So, Water Act of 1974. What is this? Why it was made? Why it was formulated? And what actually it empowers? And some few important things about it. So, if I talk about the Water Act, one very important thing to understand is this is basically an act where government felt that there were issues or concerns related to water pollution, and it was felt that to prevent and control this water pollution and to maintain and restore the wholesomeness of water, it is very important to put that under a preservation act, kind of a prevention act of 1974. So this act was specifically made to prohibit, that is to stop people to put any disposable, something which is poisonous or something which is polluting directly or indirectly into various water streams, wells, sewers, or land. Because it was as I just started with that, with growing industrialization, with too much of industries coming in, and the waste from the industries which was coming, ultimately that was thrown in these wells, these streams, these sewers, and it was affecting the health of the people. So there was these state boards to monitor, and it actually, this act has given a kind of a power to the central and the state pollution control board, that with function of these developing standards for effluent and sewages as well as quality of water to be maintained, the state board was informed that there has to be proper regulations, proper check needs to be done regarding the construction and installation of all those areas where and which in when manner the prevention and the control of water can happen. So that is what is the main essence of it. The act further authorizes the state board also to enter and inspect. It is not just only making laws, but it is also to understand and inspect that if any plant, that means where we have the record, register, or to have documents in order to determine whether the orders are going as per the boards, and if it is not, then the one who's guilty and of the offense is punished accordingly. So if violations are done, then penalties were also there. What is that penalty? It ranges from imprisonments of 3 months till 6 years, and also daily fines. So depending upon the nature of the offense which is done by people who are involved in various businesses or industries who are creating that water pollution, that is the I would say a law which has been formulated to protect water. Same manner, when we talk about air, that is also one of the very important resources. And when we say air, it is freely available, but then it needs to be protected, because that is what we breathe, and that is from where many of such health concerns also raise up if we don't have pure air to breathe. So again, keeping that same thing to prevent, to control, and to have a proper I would say an environment which is air pollution free, it was felt that a statute was made which actually was to inspect air pollution controls at intervals and to assess that what is the quality of air and how the steps can be taken in for prevention and control of the abatement of the air pollution in those areas. So this was again something where the act, again the penalty remains the same. If the officials felt that there is something where the any kind of an offense is done by people, those who are doing their businesses in that area, and where it is getting affected, the air is getting affected, so there's excess of like waste which is coming out, and it is creating any kind of health disturbances to people. Again, the penalty is for from 3 months to 6 years, and daily fines if they find that it is a continuous violation which is happening. So, if any failure to comply with these conditions are there, then it is in India where we say that there are, you can go even to the higher authorities, to go to the pollution boards which are at the state level, and can also complain. And then those, people, those who are found doing so, they are those who are given proper, I would say orders to stop and not to continue with work of such nature. Then there is an Environmental Protection Act of 1986. Again, this is nowadays which is very much buzzing, because when we talk about environmental protection in India, the act was formulated way back in 1986. But now there are certain actions which are taken. You all might have heard about the gas tragedy which was there in Bhopal. I also belong to the Bhopal only, from Madhya Pradesh. We had this in 1984 on 3rd of December. And after that, it was where they felt that the Environmental Protection Act needs to be there. So in 86, this act was formulated, which basically was to come up with measures again, so that the protection and the improvement in the quality of environment can be done by preventing and controlling the environmental pollution. So this act basically restricts certain things. And what are those things? The areas in which these industries are there, how are they going to operation, how they will be processing, how the you can safeguard those things, laying down certain procedures and safeguards for prevention of accidents, so that it does not causes any kind of environmental pollution, and also to come up with remedial measures if there are such accidents. So ultimately, the essence is to safeguard the handling of the hazardous substances, examining certain manufacturing processes, materials, and substances which may likely to cause the environmental degradations. So these are few of those things which were given very important, I would say, like importance for the in the industrial sector or in the business units to be understood. So the act further says that if there is any kind of offense which is done, the penalty is from 5 to 7 years. Previously I was just talking about 3 months to 6 years. Now if you see here, the penalty is much more. And even it goes, the fine goes to 1 lakh, and daily fine might also go for 5,000 rupees if they find that there is continuous contraventions which are happening. So government has come up with certain coastal regulation zone notifications, which we call as CRZs. They are basically formulated. They were formulated in 1991, and then further they have been amended in 2019, where CRZ comes up with certain coastal areas which are there. So how the ecological sensitive areas, they can be protected, they can be, the integrity of the coast can be maintained, how coral reefs, salt marshes, nestle ground for birds and animals can be protected, maintain them. So we have CRZ 1A. 1B talks about the tidal zones. There are areas between high tide line and low tide line. So for their protection, we have CRZ 1B. And similarly, we have then for the third and the fourth one as well. So these are all basically certain amendment which are have been rather I would say which have happened with time, so that the protection of environment can happen. Waste management rules are also something where in developing countries like India, we give an importance to this, that high consumption pattern and huge quantity of different kinds of waste leads to many kinds of health issues. So when you talk about, let's say, plastics, you talk about solid waste, you talk about hazardous waste, we talk about biomedical waste which is there. So to keep a check on that, there is very importantly this rules are there of waste management. You will find hospitals, you will find in local areas, you will find in those areas where we have these kinds of, like in industries where we have plastic waste coming in, solid waste coming in, hazardous waste coming in, from hospitals the biomedical waste which is coming in. So rules have come up so that it is the responsibility of the producers to ensure that whatever waste is generated from their products, it needs to be disposed in a very environment friendly manner. It is going to happen, we cannot avoid that thing. But then how we can do that in a very responsible manner, as a producer, as a manufacturer, that is something which all these rules basically keeps a check on. So That is what is the concept of your environmental protection rules, which we've just discussed about. So there are all these rules which have come up with time, which have been amended, related to plastic waste, related to e-waste, related to these solid waste management rules. So the years are mentioned, and you can just read out the year and then remember the entire concept. Then we further have the environmental impact assessment, which is called as EIA. Now, when you talk about making such rules, regulations, that is one part. But when I say how this is being assessed or how it is being monitored, so we have various authorities who are taking care of it. We have different committees who are actually working on it. So we have State Environment Impact Assessment Authority, which is called as SEIAA. We have the District Environment Impact Assessment Authority, which is called as DIIAA. We have DEAC, which is called as District Level Expert Appraisal Committee. And all these committees which are there, they are monitoring all these kinds of acts which are made. So whether they have been whether the proper kind of implementations are done or not. So that was all about this. Now moving on to the Forest Act of 1980. When I say Forest Act of 1980, it is very important also to understand that forest plays a very, very important role, and we need to conserve the forest in any country where we are. So talking about in India, when I say reducing forest degradation, reducing I would say going for afforestation and not going for the cutting of trees, cutting of plants, taking care of the forest which is there. So there has to be some kinds of regulations again. So there was a act which was made, which was the Forest Act of 1980, which lays down provisions to regulate the diversions of the forest land for the non-forest purpose. So this is where the government and the non-government agencies, any agency I would say, has to seek certain permissions from the central government before they go for any kind of de-reserving, or I would say cutting of trees and like felling of trees, before diverting any forest land for any purpose, whether it is for industry or whether it is for any other setup. So that needs to be prior concerned with the central authorities, and then only these kinds of proposals are given considerations. The Wildlife Act of 1972 is again which talks about protection of wild animals, birds and plants. So when you are talking about different environment areas, so this is also one of the important areas which talks about protection, about how national parks and sanctuaries, different wild animals which are there, specific plants in general, when we talk about it, how they can be protected and ensured. So this is again where I was just I was talking key in forest how it needs to be protected. So proper permission needs to be required, whether it is any mining, whether any kind of an infrastructure, or you need to go for any explosions. So proper permission needs to be granted from the central government, and then only we can go ahead. So that is how, with all these rules, laws, these national boards are established, so that the protection of these can happen in all these areas, and non-compliance of this permits a kind of strict control by imposing penalties and fines. Then there are areas when we talk about these implementation, compliances and enforcement. This is all what we've talked about, the act part. Now there's one very strong area which says about good governance, that is how it is monitored, how it is enforced, and how people apply these rules. So there are reports which are like, if I talk about TIS, that is Tata Institute of Social Sciences, there was a report which was published in 2013, and they talk about the environmental regulatory authorities in India, and it was titled as an assessment of state pollution control board. So that was observed in this report that time and again state governments have not been able to choose a very impartial or a qualified or a politically neutral person of very high standing to this crucial regulatory post. Usually when we have people, there is, bureaucracy is something which remains, and people at these positions, they, give permissions, and then it becomes very, very difficult for the protection of the environment in all these aspects. So it was felt by the Supreme Court that, these areas needs to be understood, this needs to be highlighted. The appointments when you do about people who are at the state and at the different, I would say, administrative levels, so it needs to be done with a proper care, very cautiously. You need to assign them the position so that right, laws can be implemented. So that is what is, we say, it is not only just to formulate, but it is also that there should be proper governance to monitor it, there should be proper enforcement of these acts, and further there should be proper compliance. That means people should follow up, all these things which are formulated by or which are framed by the government. So there are judicial forums on environmental protection and liability of corporates. We have in India Supreme Courts, we have in India the National Green Tribunals, which play a very important role in providing all these environmental protections. And if there is any damage which happens to environmental after any environmental wrong, so we can, just have a kind of an plea to these authorities, and then get our problems resolved. So over several years, when we talk about, Supreme Court has developed a very rich jurisprudence which is pertaining to environmental laws and policies in India. The Honorable Supreme Court, in the case of many of the areas, the Indian Council for Environmental Legal Actions, which was against the Union of India, also stated that the polluter pays principal demand, and that the financial cost of preventing or remedying the damage which is caused by the pollution should lie with the undertakings which has caused the pollution or produced the goods which cause the pollution. So it is not that only it is for the common public, but also if it is something which is felt from the government authorities, so the Supreme Court takes a very strict action against that, because they want that it should be protection of, these areas by every concerned person who is doing a business in any regard. So these are all things which you should just go through it. And just 1 minute, just give me a second. Okay, so let us just continue. So this is what I was, just talking about, that when we say that there are certain these government authorities which are there, these National Green Tribunal which I was just talking about, that is called as your NGT as well. So when these bodies are established, NGT was basically established as a statutory tribunal in the year 2010, and the main objective was that how can you come up with certain environmental justice which is accessible, effective, and also very much expeditious in India, very quick, very fast. So since its inception only, it has played a very important role in determining the liability of the wrongdoers and providing very swift justice to the aggrieved parties. When I say aggrieved parties, that means the parties which are not at fault, right? So to give them justice, the NGT and the CPCB has started maintaining environmental compensation fund as well. And this is something where this committee tries to manage certain things. They come up with certain guidelines. They calculate the entire environmental compensation to be imposed, how it is that the penalties which are, which is taken from the people, how it can be used in an effective manner. And they also have come up with certain punishments which goes from 3 years to and more, and a fine which can go up to even 10 crores for if there is any kind of a non compliance which is done under not protecting or conserving the environment. So that is what is environmental protection, what I was talking about. Let us move on to the Consumer Protection Act. So I'll share my screen and we'll discuss another law today, that is about consumer protection. So as I said, we will be talking about Competition Act and Consumer Protection Act as well. So we'll first start with your Consumer Protection Act and then I'll come to the Competition Act. If there is any questions, you can please write that in the chat box. Any questions, anything you till now what we have done you need to ask, you can put that in the chat box. Let us move on to CPA, that is your Consumer Protection Law or Consumer Protection Act. Now, this Consumer Protection Act is, which was the Act of 1986, but has been amended in 2019. So, when you talk about the Consumer Protection Act, it is very important. We will be doing it in such respect that nowadays we have too much of e-commerce which is there. So e-commerce is again some the area which cannot be I would say ignored, and that also needs to be given due importance. So saying the evolution of Consumer Protection Act was in the year 1986. You can see here it is mentioned that it was passed in the year 1986, and with the time what happens was, there were certain enactments which were there, how the consumer interest can be preserved or how it can be protected, what were the different types of provisions which were made, how the welfare can be taken of the consumers. All these things, if the consumer has any kind of consumer has any kind of governmental agencies which have served also for the purpose of all those things. Any concern which a consumer has, they can get a remedy. But then with time what happened, it was felt that now the business or the, I would say, the purchases are done through via different e-commerce. So time got extended and it was in 2019 we have the Consumer Protection Act of 2019, which was eventually notified on 20th of July, but the act is called as Consumer Protection Act. So this is all those laws which talks about not only covering, there were major, I would say, changes which were done in 2019 with the scope of the concern problem, with also the area related to the prices related to the products, what is mediation. This was not there in 1986, so this was a new area which has come up. How mediation can be done via online way, because nowadays area which has come up in which is also called as Central Consumer Protection Act. So when you write about 2019 Act, these 6 7 points which I've just said, just remember them, because that is what is the major essence and the main essence of now the Consumer Protection Act of 2019 is. Consumer authorities under the Act of 2019 have certain areas like mediation cells, we have dispute resolution cells, Am I audible?
Yes, ma'am, you are audible.
Yes, ma'am.
I
Yes,
lost my
now.
connection first, and I was just talking, from one end, and suddenly I just have, I moved back from the content to you all, and I saw that I've lost my connection. I still cannot see anyone. I'll just switch off my camera today. The internet is, I don't know. Connect through my hotspot. My dear learners, can you hear me?
Yes, ma'am, I can hear you.
Yes, ma'am, we can hear you.
And
Yes.
am I visible?
Yes,
Am
ma'am, I
I
can hear.
visible to you all?
Yes, ma'am.
Yes, yes. You are
Okay, I really don't know, but there is some. Please put that on mute. Requesting you to please put that on mute.
Yeah, we can hear you, but with more interruptions. So many
Just
interruptions.
rejoin again. Okay, just give me a minute. Yeah, there are interruptions. Just give me a minute. I'll rejoin again. Yes, now I can see my screen. So, am I audible and visible to all of you?
yes, you are visible. Loud and clear.
Yes, both of them. Audible and visible now. Yeah.
Okay, because of poor internet, I'm just switching off my camera. Okay, and in between where I'll feel like that the network is okay, and there is no this Wi-Fi is not weak or the net is not an issue, I'll switch on my camera again so that there is no disturbance. Okay, so I was just talking about, I don't know where were we connected. I was talking about different definitions of consumers. Complainant, who can be a complainant? Have you heard me till there?
Yes,
Yes, yes.
Okay, fine.
Yes,
Fine.
ma'am.
So, okay. So let us just continue. And I was just talking about, that who can be a complainant. So I was saying that there are so many, different areas when we talk about, and these all can be complainants. And, if there is any such concern which people feel that any kind of a harm which is done to them in case of any product or services what they have availed, so they can always complain, they can always put forward their concerns either themselves or by their legal hires or by maybe in we talk about, or maybe when we talk about authorities, if there is a death of consumer, then maybe by a legal hire a representative, as I just said, minor by his parent or a legal guardian. So many law has given so much of relaxations related to this. Now, what is a complaint? Complaint is basically said to be an allegation. Now, what is this allegation? This means anything is given in writing made by a complainant. I've just explained you who can be a complainant. So if he or she feels that he or she wants any kind of a relief under the act, so the section 2 subsection 6 of that says that how they can apply for it, how they can demand for it. So it covers the any unfair contract or trade practices. It talks about certain restrictive trade practices. What is restrictive trade practice? Something where the law has restricted you not to do a particular thing, and you are found doing it. So that is also where you can register your complaint, and that is where the law is going to protect you. So any particular service provider or maybe any seller has done any unfair contract with you, an unfair trade practice with you, or a trade practice he has done which law has restricted them to do, and it has been done and you want a relief on that, so that can be filed under complaint. If there is any kind of a defect which you find in the goods, if the services which are hired or availed by you are suffering from any kind of a deficiency, if the trade or the service provider which has given you certain goods or services have charged excess price, or has displayed the price or goods in some other manner but have delivered you in the other manner, the goods of any kind of like packaging is not proper, the listing is not done, and whatever was agreed between the parties, if it is not according to that, that also can be registered as a complaint. Any kind of a hazardous or a life threatening thing which has been given you as a, let's say, service without prior informing you that it can also be injurious to your life and safety, that can also be termed as a complaint if a person feels so. So all those things where you feel that you want to claim and you want to get a relief from it, and you feel it is not as per the nature of contract, law gives you that much of provisions that you can register those things and get a relief under the Consumer Protection Act of 2019. Now, how can you file complaint? So when we talk about filing of complaint, there is certain procedure for it. Let us talk about that procedure. I just said few minutes back that there are proper forums how we go ahead. So it goes to, first you go depending upon the nature or the, let's say, the amount of the problem which is there, you go directly to the district. Then if it is higher, it goes to the state, and then it goes to the national. If it is below 1 crore of rupees, you go to the district. If it is till 10 crores, from 1 crore to 10 crores, it goes to state. And if it is above 10 crores, then it goes to the national level. So finally, what happens is you need to give a written complaint along with certain evidences. That is very, very important. So there are certain receipts, and after you fill in that particular area, or rather I would say after you fill in the proper complaint, and then you give that in the form of, let's say, as directed by, as I just talked about, to which concerned person, which concerned jurisdiction, you need to forward that. So within certain period of time, you need to give your complaint, you need to mention your concern, and if you if you're not satisfied by one, then you can go to the next and further to the national level. So these reliefs are basically given, granted on all these areas which I've just talked about. If you want the, if you put a complaint, the removal of the defects will be done by the person. The defects are whatever were there, they are going to be replaced, refunded. You are going to be given the award of compensation for any loss or injury if it has happened. You They need to withdraw those hazardous goods if they have offered you during the sale. Any loss or injury which has happened, or because of that you have suffered a large number of loss in that, so they compensate you for that amount of money. And basically, if you feel that there is any kind of thing which affects is misleading, and the consumer has purchased a product believing that particular advertisement, then also the complaint can be filed. That is also something which is given you due consideration. So now there are certain powers which are given to the Central Consumer Protection Authority. I was talking that previously also. Initially, we were not having this particular CCPA 1986 Act. Now with 19 Act, which is amended, we have a proper authority which is established, which is basically officed or headquartered in India only, and it has started its activities in consumer welfare. So what is this and why is this formulated? So if you want to file any complaint, consumer can directly approach to CCPA rather than going to the state, district, and then the national levels. So you can file a case again, district magistrate if you want, or you can also refer the matter directly to the CCPA. Got my point? What I said? I hope you are able to understand what I'm, talking about the Consumer Protection Act. You would also be having similar such acts in your country as well, right?
Yes, that is it, ma.
Yeah. So how
Yes.
do we go ahead with like any kind of a complaint there? I've shared about India. Can you share from your side how it works?
But here in Nigeria, I think we have a Federal Consumer Protection Agency where
Okay.
customers can lodge complaint in case of irregularities by company or other organizations that deliver goods or services to them.
Okay. Kamis, thank you so much for sharing your answer. Anybody else who would like to share? Anybody who has felt that there was any kind of a malpractice or excessive price or a damaged product which was shared to him or her, and you have ever experienced anything of filing a complaint and then getting a remedy for it? Anyone? See, as a business or as a student of MBA, when you are into doing, business administration, it is very important that you understand that while you do business, why are we studying this? What is the relevance of this subject? The relevance is because when we deal with certain business activities, it is important to understand different acts which are there. It is important to understand that you cannot just do business at your own rather I would say at your own comfort. You need to follow certain laws, you need to abide by certain rules and regulations. And if there is any kind of a damage which happens, so how as a consumer and how as a producer, where you can approach, how you can approach. So this is what is all this block is all about. So you understood till what I have explained you till here?
Yes, ma, I really understood.
Okay, thank you, Kamis. Anybody else?
No, it's fine. It's all understood by me.
Okay. So let's proceed then. I'll just move on. I hope you all have written your names in the chat box. Can you just write that again because of the
Yes,
connection, poor
yes,
connection? You know what has
we
happened? Yeah, I cannot see that.
yeah, it's because you left the meeting and joined
Yeah.
again, but we will also rewrite it again.
Yes, yes. Because of the internet, poor internet connection today, I lost the connection and I have to rejoin. So I cannot see what is written in the chat box. Okay, so let us continue and we'll move on to what I was just sharing with you. That is, CCPA is also one of the central authority where you can put forward your complaints, and CCPA has certain powers. That is, if they want to inquire or they want to make, they find that there are any violation of consumer rights or there is any unfair trade practices which are done. So we have SU motto, which is, where the central government can ask for uh, how the speed can be processed and how the solutions can be given very, very quickly. So the authorities can recommend the government also to come up with certain international conventions to protect the rights of the consumers. And basically, when we talk about CCPA, it has mandate to promote research into consumer rights. So it is very much important that the consumer should be first aware about their rights at the ground level. So there are NGOs, there are different types of agencies which are working to encourage the consumers to understand what are their rights, and if there is any kind of a harm which is done or any hazardous goods or services provided to them, so how they can be notified, how they can then be alert. And it is basically advised to the central and state government also that they should come up with certain necessary guidelines in preventing these unfair trade practices so that the consumer rights can be protected. Now, as I was just talking about few minutes back, where I said that in 1986, when this act was passed in India, and today when we talk about, there are certain changes which have come. What are those changes? We never had this concept of CCPA. We never had the concept of product liability, and not also e-commerce. So, product or service liability is here when we talk about that the one who is providing the product or service is liable in case of there is any kind of imperfection, deficiency, inadequate service, negligence, or any kind of consciousness withholding of information which has caused harm. So that is where the product seller needs to be very much aware about it, and they are going to be held liable. They cannot say it was given to us by the manufacturer or the producer. If you are the one who's providing that product or service, the product seller will be liable, and they are going to be held responsible for the harm which happens to the consumer. So the product liability provision is also something which provides exceptions from the liability to the product seller in case the product was misused, altered, or modified by the consumer. So that is what is the concept of product liability basically is. E-commerce, I think you all are aware about it, that is doing business online. So when we talk about e-commerce, there are various ways of shopping nowadays. We have tele shopping, we have direct selling, we have multi-level marketing. We do it through different electronic means. We go for offline and online things. So basically in CPA, what we have done is we have certain rules for e-commerce, and that is where we apply these rules when we say that if the goods or services are bought or sold on any digital or electronic network, including digital products, so how do you go ahead with that? So all models of e-commerce, including the marketplace and inventory models of e-commerce, are part of it. Retailing, multi-channel, single hand brand retailers, single brand retailers in single or multiple formats, all are part which are covered in this. So any kind of an unfair trade practice which covers any mode of e-commerce is something which becomes a part of under the law of your the Consumer Protection Act of 2019. Now, this e-commerce, when you do, it is important that every e-commerce entity should establish this adequate grievance redressal mechanism, so that if there is any grievance which a consumer has, they have a grievance officer and they can redress or solve that particular thing. So you might have seen, we have people nowadays asking, that if you have a grievance, please write down your name, your contact detail, and our officer is going to come back or revert back to you. So that is the role of a grievance redressal officer as well. Every e-commerce should also provide certain informations if there is any kind, because you're not physically present, right? You're not physically in front of the person. So it is important that the information should be very clear. It should be accessible on every platform where you are providing the product. So name, website, details, principal geographical address or the headquarter of all its branches where the you're doing your business, legal name of the e-commerce entity, contact details, fax, landline, mobile numbers, everything to be well informed to the customer or the consumer who's purchasing a thing. So every e-commerce should also uh, put up best of his efforts to become a partner in the convergence process of national consumer helpline with the central government. This is also one part of it. E-commerce entities need to offer imported goods or services. If they are into that business, they need to mention the detail name and the details of the importer from where they have purchased. It should not just be provided to the consumer without making them aware about it. No e-commerce entity shall impose any cancellation charges on consumer canceling after confirming. So if in a e-commerce you're doing buying anything, so the e-commerce entity, that means the seller, cannot impose any cancellation charges on a consumer canceling after confirming. So these are all those areas which have come up under the act. Certain liabilities are also mentioned, as we have talked about certain duties. So there are liabilities also. There are certain duties of sellers at market price. You can just go through them, and you will have an idea about it, because this is one of the very, I would say, exhaustive data which is there. There are too many things for me to cover in academic counseling of 1.5 2 hours. So I would request you. I'm just covering few important points out of it. So just read that thing, and you will able to connect with me what I'm saying. The broad perspective when I say certain duties are there, liabilities are there to the people, those who do business on online through online mode, and there are certain rights which are given to the consumer, making them aware about it, that what are their legal rights which are provided to them by the government. So amendments keep on happening. We have formulated the law in 18 act in 1986, but looking at the practices of business today, we have come up with the act of 2020. Then there are amendments which are done in the year 2021 as well, and on a regular basis, looking as per the complaints and the areas of the concerns of consumer, all these changes keep on happening. So, see, consumer protection councils, which are at state, central, and district level, have been made because they want that the problem should be addressed at the lower level. And it is that minister in charge of the consumer affairs also keeps a check that whether the official and the non-official members at the state, central, and the district level are following their objective or the duties to protect the consumer right. As I have said that in the beginning about mediation, and I said that in the new act of 2019, we have a new process nowadays which is called as mediation, where if parties are having any dispute and they voluntarily agree to settle that dispute amicably outside, so through that consensual process, the party can exit anytime whenever they want, and they can go to the third party intervention, that is mediation, and in a very closed process with total confidentiality in nature. The mediator is one who plays a role of a facilitator, and the parties actual decision makers, and they control the whole process, unlike the court. So if the people are satisfied by the decision given by the mediation, then they do not go to the filing a complaint against the state, district, or the national level. So the process is comparatively fast. The role of a mediator or a facilitator is actually to give you decisions where you do not end up into spending lot of money, wasting too much of time. And as a mediator, you can easily closely converse, that person can also converse directly to the parties in better position, give them better solutions, unlike what happens in the courts, where you cannot be that informal. So that is all about the Consumer Protection Act. Okay, I hope I have given you an overview about the entire act, and you understood that what this particular act in India stands for. Is it clear?
Yes, ma'am.
my dear academic learners, I would be really very happy if I hear, an answer from your side, because that keeps me also motivated.
Okay, ma'am.
Okay, so now let's move on to the last area for today, that is the competition law. I said you previously also, please prepare notes with me while I'm explaining so that it becomes easy even for you to write down things, right? So quickly, in another 15-20 minutes, I'll try to wind up this, and then we'll be open for your discussions if you have any questions to ask me. Competition law is basically a law which is kind of, I would say, referred to as an antitrust law. It plays a very important role in ensuring the market economy, the dynamics of market economy. It is basically to take diverse measures and approaches to ensure that fair competition among firms is there. In turn, it can also augment the customer welfare, because if it is going to be fair competition, so ultimately it is going to benefit the consumer. Prevails for that, we have a competition law or a competition act, so that the economy also in a healthy manner, and the consumers are also, which they enjoy good product at a reasonable price. So the competition law basically is something which talks about having an undisputed market power, which is open up without hindering consumer welfare by excessive prices, reducing the possibility of business can utilize resources, supply products and services, and keeping detrimental services or providing detrimental services to the consumers at a lower price. That is what is this competition law is all about. Okay, so when I talk about the different types of laws which are covered under this, we have a MRTP Act, which is called as Monopoly Restrictive Trade Practice Act, which basically means that any kind of this act was formulated to control monopolies. So if you want the economy to grow, it is very important that there should be healthy competition. So we should have a monopolistic competition rather than having monopolies. If we have monopolies, that means it is single seller. So they are going to control the price, they are going to charge excessive price, and they are going many sellers, those who are there. So it's a healthy competition. The sing person, one seller does not decide the price. So it is where you have a kind of a market which is more towards consumer. Through this MRTP, what has happened in 1990, when there was liberalization, policies have come up to the NEPs, that is new economic zone policies or new economic policies, which I was just talking about, the rise of globalization, liberalization, and privatization. There were many of delicensing which was done. There were many of deregulation of sectors which were done. There were, certain kinds of control which were taken from the public sector, and industrial activities in turn sector were now MRTP was basically to observe that if there's any incompatible with the shift in industrial policy. So this focused on competition and market orientation. So to control that, MRTP Act was there, that monopoly does not remain and no harm is given to the consumer. Then we have Raghavan Committee report, which basically talks about, that it was responsible for giving various, I would say, suggestions for the competition law or the competition act formulation, where it recommended government in May 2000, this highlighted the need for competition policy, mentioning that for efficient allocation of resources and to regulate concentration of economic power and to promote consumer welfare, it is important to have a competition policy. Further, this committee has in enforcement of authority so that the competition commission of India can have proper control over this. So ultimately in 2002 the competition act was passed, and this came up with the recommendations of the Raghavan committee that fair competition should be there, assuring to economic development of the nation. So now when you talk about this, it focused on market allocation. It also focused on certain kinds of agreements to be done in favor of the economy and not in the favor of just the single seller doing. So there were vertical enterprises at different levels of productions are there. So when you have different productions, like let's say different levels of production in chain, so they going for certain agreements. So it can be like not horizontal agreements I'm talking about. Horizontal agreements are when you talk about at same level. Vertical agreements are where we talk about different levels. So maybe when you talk about tying in the practice of supplying a market, tying product while making the buyer purchase a second product is known as a tied product. Okay, so tying may be employed by a dominant firm for increasing the sale of tied products in the market by leveraging its position with respect to the tying product or leading to the horizontal foreclosure of market. So it is basically in the horizontal manner that is moving at the same level. So many such agreements, distribution agreement related to supply agreement, because what happens is when you have people who are at the same level, you might have heard about, they come together and then they fix certain prices, and then they exploit the consumers, or they exploit the the people in the society or in the people at large. So it is very important that these kinds of agreements need to be made by the government, giving them the clarity that how it can be formulated and how it can be done for the welfare of the people at large and not the welfare of the sellers only. So unfair trade practices are not there, any kind of a discriminatory things are not there, any kind of an indirect means is not enjoyed by the seller. So to avoid all those things, these competition act or a competition policy was formulated. Usually when we have mergers and combinations, or rather mergers and acquisitions we have, so we see that people have the different levels, they join together horizontally or is basically to keep a check on all those things. It is important that this law or this act was formulated. Got my point? What is competition act?
Yeah. Can you come again? My network is cracking. My network is fluctuating, so I can't be able to hear you very well.
I just said that when you talk about competition law, it is basically kind of an economic legislation which basically signifies and plays an important role in managing all the different dynamics of market. What happens is when you have different provisions which are related to these anti-competitive arguments, or maybe the abuse of dominance and combinations of these sellers, so they come up with such kind of a market where unfair trade practices happen. So to ensure those that fair competition in the market for the welfare of the consumer, this particular law, this particular act was passed. This is where the competition act basically says that it is enforced in such a manner that it is where you benefit not only the seller but also the people, those who are in general, when you talk about consumers, they are the new products are shared to them, good quality is given to them, innovations happen, non-price parameters are there which is given them, rather than just only targeting on the price and enjoying profits, huge profits. So there are certain times when we say agreements are done in the horizontal or vertical manners by the firms, so that they can enjoy more resources, more power, more control in the market. So to avoid that and to have a healthy market, this competition act was there so that the firms at the same level can understand that there should not be monopoly, there should be more of the monopolistic market which should prevail. So there are companies like, for example, if I say Abbott Laboratories and Sem Corporation, they are a combination which is notified by the CCI under 6 subsection 2 of the Competition Act, where it is the Abbott Laboratories and St. Jude Medical. They basically deal in manufacturing, sale, and research of global healthcare products. They're all, both of them are medical companies. So SGM, on the other hand, when we say that is St. Jude Medical, is a global medical device company in US, and they engage in production, development, and research of basically the cardiovascular and in the function of both the parties, that is when they come together and intersected in the manufacturer of small hole VCDs. VCDs are basically the healthcare devices which are used to consider the hole arising out of the arteries. So as a result of combination, the market share of the combined entity together will elevate to around 90 to 100%. So this is what, as a case study I'm telling you, that what happened then further, the entity undertook a voluntary modification by agreeing to engage in a divestiture involving the small hole VCD segment of SGM. So there's a third party provider of cardiovascular products also, which is based in Japan, not having any structural or financial linkages with these parties. So CCI has given its approval that yes, under the Competition Act, you can go ahead, you can do such kind of businesses. Again, I say, for any research, for getting synergies, for eliminating competition, for economies of scope, economies of growth, if you are doing any kind of those things, mergers, then that is always good. But if it is done to exploit the consumer, for fixing higher prices, for holding the products, hoardings, and all those things, then that becomes a kind of a loss for the economy as well as a market. Am I clear till here?
Yes, ma'am.
Okay, so if you have any questions or concerns, you can put that in the chat box. It's already 9 here, and if we don't have any concerns, that is what is all from my side for your block 6. I've covered those three areas which are there in block 6. I don't know, yesterday there was some confusion. I said that it is done because the module was very small, so we finished that early. But today, as there were 3 units, there were like the content was more, so I've tried to cover all those 3 areas. And my request is, go through that. If you have any concern, you have any problem, we can always have another meeting and we can discuss those points. Any
Okay,
questions,
ma'am.
any concerns from your side?
No, not actually, but you see, all these laws and policies, we have those policies in Nigeria, but most of the times it didn't favor small scale enterprise because capitalists are too many in the market, and there is poor implementation of these policies and laws. So it's very hard for a small scale enterprise to start a business and succeed. Most of the time when businesses started small and they end up collapsing because government agencies only put eye on such small scales, while the capitalists will be inflating and increasing the prices of goods and services anyhow without the government implementing such policies. Thank you, ma'am.
Very, very true you have said, Kamis. I truly agree to you because it is something, to safeguard that, to protect that, to give you a kind of an understanding about it. That only is the prime reason why we have the formulations of these acts and laws which are there in any country, whether it is India, whether it is Nigeria, whether it is US or UK, anywhere we are talking about. What happens is when you have laws, when you have certain regulations which are there, it gives you a proper guideline how the things needs to be done, and exploitations also do not happen to a very great extent. People also have a fear that there are going to be fines, there are going to be penalties, there are going to be imprisonments. So then they also fear doing things which is against any kind of the law or the regulation, so malpractices are also avoided.
Yes, indeed, ma'am.
Yeah. So, if any other question or concern is there, I request all of you to please put that in the chat box. Or else, we will end the class here. I'm very thankful to each one of you. It was a very good experience with you all. I have finished today my academic counseling for the subject which was given to me, that is business law. And I hope with my some knowledge I have helped you to understand certain concepts. I know law is a subject which is very much in detail, and in academic counseling of 1.5 2 hours, it becomes really difficult to take up all those areas. But then definitely, as you read and you go through, there are going to be certain points which you can just write down, those areas which are important. Remember, in law, when we write, it is very important to mention the act, mention the section, mention certain objectives of that particular law. As in Consumer Protection Act, also, I have spoken about that. CCPA is something which is very important. Mediations are very important. You can write, the questions can come on also certain kinds of penalties, so prepare that part. Who's the complainant, what is the complaint, what are the areas, what about state, district and national commissions or councils, what are the amount of money which is considered for certain kinds of problems, or rather the complaints which are registered. This is what needs to be remembered. Otherwise, when we talk about learning each and everything, one by one, line by line, that becomes really difficult. But yes, if you would be knowing the essence of it, that will be very easy for you to write your answers. Okay.
Okay, ma'am.
Okay. Thank you very much.
Yes,
That's
ma'am.
been helpful.
I
Thank you
hope
very
you all
much,
also
ma'am.
enjoyed with.
I really enjoy
Thank you
your
so
classes, ma'am,
Yeah, it was an
because
amazing experience. Thank you.
I'm facing challenges in this aspect with my new established company, and I find it very difficult in understanding these government policies. But I think I will employ the professional lawyer to help me guide on all these things so that I won't be having problem with the government agencies on these issues. Thank you very
All
much.
the very best, Kamis. All the very best. All my prayers for you.
Thank you, ma'am.
Thank you.
Okay, so if there are no concerns or questions, shall we end the class?
Yes, ma'am.
Yes,
Yes, please,
please.
ma'am.
Yes, ma'am.
Yes, yes, thank you.
Yes, it's okay. Thank
Thank you
you.
very much.
Requesting
Thank you.
everyone
Be
to please.
blessed.
Thank you so much. Thank you, Grace.
Thank you, ma'am. Goodbye.
Bye, bye, man.
Bye bye.
Yeah, goodbye.
Goodbye. Requesting others also to please leave the class. Suleiman Shehu, please leave the class. Emmanuel,